Hello, everybody. I'm Diane Cohen, and I'm joined by Lori Kammerer. Today, we are going to be learning about the legislature and things that we can expect to see in the workers' comp system past 2024 and what we can expect in the future. Lori, can you tell our audience who you are and what you do?
Sure. Good afternoon, everyone, and thank you for including me in your webinar today. Thank you to MacroPro for putting this together. I'm Lori Kammerer. I have been in the workers' compensation advocacy position for about 28 years. I started as the director of the California Coalition on Workers' Compensation. And prior to that, I was working on with the CCWC. I was working with them when we were looking at whether to put the workers' comp issue on the ballot. And so after doing some polling, the researchers discovered that putting workers' comp on the ballot in terms of benefit increases and system improvements would not be a winning initiative. So the organizations formed a large association of employers, and I did that, worked with them for about 15 years before I started my lobbying firm in 2002. So that's a little bit about me. I'm in Sacramento. I am 5 minutes away from the Capitol, and I spend a lot of time over there. And I really enjoy working with the California Professional Photocopiers. And they are very, very influential and in working with employers and with labor on identifying system improvements. So that's a little bit about me.
All right, well, thank you. And I do work with Lori when with that group she was talking about, the Coalition of Photocopiers. I happen to be the vice president of that particular organization and get to work with Lori a lot because of that. All right, well, Lori, it's the holidays, and we've been asking our friends to give us some answers to some questions. So for those of you who are out there, I'd like you to answer the question in the chat box. And thank you, Stephanie. Appreciate that. I do like my Christmas tree this year too. All right, so the question, Lori, is to you: who gives better gifts, you or your partner? And everybody out there, please answer the same question: you or your partner?
I think that I give the better gifts because I put a lot of thought into it. And but then I have to say that my husband is very good about dropping hints of what would be his ideal Christmas gift. So I think it's the two of us.
I'm going to say my spouse is probably the better giver. I sometimes he'll give me hints and things, and I won't necessarily get the whole picture. So I think he is the better giver. But let me see here. So Annette says, or Lynette, I'm sorry, she says that it's equal, just like you and your husband. Claire says that it's her. Definitely, let's see, I definitely give better gift ideas. Sandra, another Sandra says that she gives herself the best gifts. Oh, I like that. And I do have a story on that at the end. If you stick at the end, I'm going to tell you how my husband and I do presents. Mary Jane says it's her. Ron says himself. Patricia says I do for everyone else, but he gives me great gifts. Oh, that's really lovely. Stephanie says her husband is a better giver, but she's the better gift wrapper. You know, and a pretty package really goes a long way. And then Brandy says that it's equal. All right, so what's not up is the screen. I'm just going to do a little bit of housekeeping. As a reminder, today's webinar is worth 1 CEU in California. You should be receiving that in about an hour. There are handouts in today's presentation that Lori's providing, and she's giving us a lot of information. So please download that because there is just so much information. I don't think you'll be able to keep taking notes on absolutely everything. This is going to be on the MacroPro YouTube channel, as are all the other 12 CEUs of Christmas and every other webinar that we've ever done. I believe there's something like 50 different programs on our YouTube channel, so you can check that out. Your certificate should arrive in approximately 1 hour. If you have any difficulties with that certificate, please let me know. I need to know within 30 days in order to assist you. That's all of the housekeeping I have. Thank you guys for telling us who's the better shopper in your family. And Lori, I'm going to turn it over to you now.
Okay, great. So I'm going to go ahead and we have a lot to cover, and I'm happy to take any questions. Maybe if I can, I'll go through the legislative, uh, uh, the bills that we can expect to see, or we will see in January that the governor signed. And then I'll go through the regulatory update, and then I'll give you a forecast of what we're seeing that we will probably see in 2025. And so in between those three segments, I'll be happy to answer questions and then also take questions at the end in case you think of a question you want to ask. So I'm going to go to the next slide. The update of the 2024 legislative and regulatory session and what we can expect to see in 2025. So I wanted to highlight some of the bills that that the governor signed, and then also a couple of the bills that the governor vetoed. This was kind of a quiet year in the workers' compensation front because we had an election year, we had a changeover in the legislature, and I'll cover that when I talk about the forecast for 2025. But there were some interesting bills. The disability payments, this is an interesting bill that was passed back in 2018, I believe. And it enables the claims administrator to provide a prepaid card that the injured worker can use to collect their benefits. This bill was negotiated back in 2018. At the time, the banking industry was opposed to it because they were claiming this was going to be expensive. They were going to have to come up with a new 4-digit number that is different than the debit cards that we have now, and that they were going to have specific requirements for workers' compensation disability payments. Well, that fell on deaf ears when the bill was heard in the various committees, because in the research that was done, they found that there are a large number of injured workers who are either unbankable because they are undocumented, or because they just don't have a checking account. And so it made it difficult for them to cash their permanent disability or temporary disability checks. So Senator Hill at the time came up with the ideas, why don't we do a prepaid card account similar to what we have for the EBT and the banking cards that people use, the debit cards. And so they tried that, and it actually worked out very well. The commission was going to do a study, and they're actually still going to do a study on the question of whether injured workers are taking advantage of the prepaid card accounts. And they wanted to see, if they're not using this, why do we need it? Well, the study that the commission was doing was not has not been done yet, and that's on their docket to do. But so what the bill does, AB 1239, is now it extends to January 2027 the use of the prepaid card accounts instead of having it expire on January 1, 2025. So I think it's a good program. It did not increase the costs, and labor, just wants to make sure that they are taking advantage. Injured workers are taking advantage of this prepaid card account opportunity. And then the second bill that I thought would be of interest to everybody is the AB 1870. And this is a bill that the California Applicant Attorneys Association sponsored. And what it does is it puts out a new posting requirement in places of business where employees can see that if they do need to seek advice from an attorney, that they have that ability to do that. But it also lets them know that if you do seek counsel, that it may come out of your award or benefit. And this is really primarily for those workers who are in the medical provider networks, which the majority of employers in California participate in the MPN program. And so this basically is a notice requirement that goes on the postings, and it also goes in the DWC Form 7, which is given to the worker when they file a workers' comp claim, so they know that they do have access to an attorney. So the bill is pretty straightforward. The governor, I think that was one of the first bills that the governor signed back in late August, early September. This is an interesting bill too, and quite frankly, it's one of the few bills that we see that was authored by a Republican. The majority of workers' comp bills that go through the system that get signed by the governor are by the majority party. So Diane Dixon authored and the governor signed AB 2337, and all this does is extends the requirement, or not requirement, but the ability for electronic signatures. This first came out during COVID, when the governor had said, you know, since we are not doing things in person, that a lot of documents are not being sent in, or people are not in the office at DWC to accept documents, or the Workers' Comp Appeals Board are not in the offices to accept documents, that electronic signatures are approved and okay. Well, that was going to expire. Actually, it did expire when the governor said we're no longer, you know, in the pandemic, and that people can be meeting in person. And so he went ahead and so the bill was put forth so that they could keep that electronic signatures ability going forward. So this again was a straightforward, non-controversial bill that actually proved to work very well for the parties, to be able to not have to do everything in person. SB 1058 by Senator Ashby. This is a bill that it seems that she introduces it every year. At least I've seen this for the last couple of years. And this is extending the leaves of absences for park rangers and enabling them to have full salary, full benefits, and so without their loss of pay. Currently, it's law enforcement and firefighters who are able to be off on their workers' compensation disability with full pay in lieu of temporary or permanent disability, where they would be getting, you know, 2/3 of their average weekly wage. So this bill enables them to, or would have enabled them to collect their full pay. This bill was vetoed by the governor. I read the veto message, and the governor, you know, basically said that because of budget issues that we have in California, and also the fact that the park rangers and park employees are covered by workers' compensation, that that it would be too costly to the system. It would impact the cities and counties in California, increasing their costs. So this bill will come back again, and I'll cover that a little bit later in the presentations. Senate Bill 1205, this is very interesting. This is by Senator Laird out of Santa Cruz, and dealing with medical treatment in the workers' comp system. This bill was sponsored by Cal Labor Fed and the California Federation of Teachers. And basically, they were concerned that workers, when they requested to go see their medical provider for their workers' comp claim, if they're still able to be on the job, that they were not given the time off to be able to go to these appointments. And by law, if the worker needs to have medical treatment, the employer has to give them that time off. Some of the employers basically, you know, were intimidating the workers, and so that's labor's answer was that, okay, if you know, we're now going to make it even stricter, that the employer has to give the worker the time off, and not only that, they have to pay their travel costs, their meals, and lodging, if lodging is required, if they have to seek treatment that is not close by. And this bill was amended several times. They tried to water it down to make it very, you know, very easy bill, that it would be voluntary for the employer to, you know, or for the injured worker to work with the employer to see if they could get their medical treatment either before work or after work. Well, a lot of times if you're off work at 5 o'clock, going to see your acupuncturist for a 5:30 or 6 o'clock appointment is, you know, just not doable. So after all of the back and forth and concern about the cost, that would be associated to the employers, and also just to make this workable, the bill was held in the Assembly. They held it in the Appropriations Committee due to the cost. And as I recall, the Division of Workers' Compensation said just the cost to the state of California alone, because the state of California is the largest employer in California, that it was going to run about $7 million. Well, that was a budget buster. And so therefore, I think that Senator Laird, heard from the governor's office, this is going to be too expensive, and so the bill never moved forward. I do expect that this bill will come back again. Okay, and here's a big deal that was a landmark negotiation this year. I think the Private Attorney General Act of 2014. The PAGA, and for anyone who may not be familiar with PAGA, this has been an issue that has been going on for decades, where an aggrieved employee can sue the employer if there is the wrong zip code on their paycheck, or if there is any type of workplace violation, such as a worker who presses or pushes their time clock on the outside of the building as opposed to the inside of the building. For workers that may have there may have been an error in their benefit, or any aggrievement that the employee has, they were able to sue the employer. Well, after this was going on for a long time, employers were having to deal with the attorneys who were filing these class action lawsuits, because if one employee was aggrieved, the entire company was aggrieved. And so through research and evidence, it was determined that the trial attorneys were getting all of the money from the employers, all of the settlement, and the injured workers were getting pennies on the dollar. And so the California Chamber of Commerce came together with the Cal Labor Fed, who both of them decided that rather than go to the initiative, go through that process and reform the PAGA rules, that they would try to have the legislature do their job and pass a bill that would work for both the employer and the employee. So what they came up with, I think, is very good. It took this issue off the table for 2025 and took it off of the proposition ballot list. But so basically what it's doing is it's bringing the parties together. It's reducing those penalties. It's giving the employer the opportunity to cure whatever mistake they made. And if it was willful, then they're on the hook for penalties. If it was something that was, clearly a mistake, not knowing that the, injured worker needs to press the time card when they get in the door rather than outside of the door, or no, excuse me, I had that backwards. When they're outside the door, they have to push the time card, and as opposed to when they're inside. And also giving the employer the opportunity to correct any mistakes they may have made on the payroll summary, or whatever the aggrieved employee is alleging, that it would give the employer the ability to correct that mistake. And that's where we see it broadens the right to cure and expands the labor code sections that may be cured prior to the litigation. So it gives that employer, I believe it's 30 days to cure before any litigation can happen. And it used to be that, or until this becomes effective in January, that they could file a class action lawsuit and the employer was on the hook immediately, didn't have an opportunity to cure. And so they're looking at cutting out a lot of the trial attorney involvement, bringing this into the court system in order to resolve these disputes. This bill was signed by the governor, and there were two bills. So there was one in the Assembly and one in the Senate. And I think this was a really important, very good progress for both labor and management. And so there's just some information here in terms of the intent of the bill was to expedite the resolution, lower the cost to the employers, but also give the aggrieved party, should the employer willfully have neglected their responsibility to the employee, to put more dollars in the aggrieved party, the aggrieved employee's pocket. So this, I think, was a major deal. It's interesting. I was thinking that this, if we didn't have the initiative, that this issue would have been put on the bargaining table in 2025. This is a good reason if injured workers want to see an increase in permanent disability, then the topic of PAGA would have been a good trade-off. How can we put more dollars in the injured worker's pocket, and how can we make the system more fair for the employers? But they decided to take it off the table now, and I think that this is a major step in cutting back on a lot of these civil lawsuits. Oh, and then 636. This is an interesting bill. This bill was a sleeper for 2 years. We just finished the second year of the 2-year session, 2023, 2024, and this bill was introduced in January of 2023. The author held it. He made it a 2-year bill. The bill didn't go anywhere in 2024, and we were thinking, well, Senator Cortese is probably holding this bill in case there's any discussion of system reforms or workers' comp benefit increases. Well, the bill came out at the last minute, and just basically, dealing with heat and heat-related issues, and dealing with it changed a whole bunch of different bills, to the point where the governor said that the bill hasn't gone through the appropriate policy committees. It was a last-minute change, and that was pretty shocking. I thought that the bill would have been able to go somewhere, but anyway, it was a bill that the governor vetoed, and really I think that the author held on to it for too long. So that didn't go anywhere. Okay, and then the rebuttable presumption. This is by the same author, Senate Bill 1299, and Senator Cortese did not have a good year. The governor vetoed this bill too, that basically would provide the preponderance of the evidence that if the employer is not providing the protections for heat, which they're already required to do through Cal OSHA review, et cetera, he wanted to basically make this into a separate issue. And so, but what they also did in the bill that was hidden very well was that this bill would require that private employers, not public, right? Because public employers are the state, right? The public employers, that private employers could only use doctors who were licensed in California to do their utilization review. And so the thinking was, and I think from where the governor was coming from on this, because the general thinking of employers is that if you've got a broken arm in California and you've got a doctor assessing that injury, well, that doctor in California is probably going to come up with the same medical opinion as the doctor in Texas or the doctor in New York. A broken arm is a broken arm. And so, how that arm is treated and how the worker is brought back to work is pretty close, if not exact between the different states. So this was a bill that clearly wasn't baked, wasn't ready for time for, wasn't ready. And so the bill was vetoed by the governor. Okay, does anybody have any questions before I get into the regulations on the legislation that the governor signed or vetoed this year?
There's no questions, Lori, at this time.
Okay, thank you. I can't see that part, so thank you for telling me. Okay, so regulations. The Division of Workers' Compensation is busy busy, busy, busy. And on the top of their list, thanks to the Coalition of Professional Photocopiers and their advocacy, is the copy service fee schedule cleanup. This is an important issue for the copy service. The CPP had put together some regulations, some draft regulations that would clean up the existing photocopy regulations, and put it together so well that it really gives DWC a very good position, puts them in a great position to be able to adopt these regulations. The pharmacy fee schedule, this is another area that the DWC is working on. They have had comment periods, and I should say too, with the copy service fee schedule, we should see public comment and a review of the draft in January. And I would say the same with the pharmacy fee schedule. With the last couple of months, because of the holidays and everything else, I think that they're going to pick up and work a lot cleaner and faster in 2025. Same with the electronic filing and EAMS. This is a project they've been working on for the last 2 years. The 5710 deposition fees they're reviewing. I think those will probably see fee schedules in the spring. Same with the interpreter fee schedules, e-signatures. Now the supplemental job displacement benefit, that's a big deal. And I'll get into that in a little bit more detail to discuss the findings that RAND had come up with. So I'm going to discuss that in more detail. That's a huge issue. And then, of course, the audit unit regulations. Those are at kind of like the bottom of the list. They are really, I should say that the administrative director and the chief counsel of the DWC are really focused on the copy service fee schedule, pharmacy fee schedule, and the filing in EAMS. So those are their 3 priorities that we can expect to see at least in the first quarter, if not by January. So they're also working on a QME, Qualified Medical Examiner study. They have a contract with RAND Corporation now. And the question that they're looking to address is, does the current medical legal process satisfy the purpose of the systems as it was initially envisioned by the legislature? And there have been numerous hearings over the past 3 or 4 years on the QME process. Is it working? Do we have enough evaluators? And is this process working? And they're also looking at the medical legal process, including the fee schedule. And is this, going to be sustainable going forward? So these are kind of the questions that we're going to see possible answers to. And again, that's going to likely be happening the first quarter in 2025, or the best, the second quarter. And then in what ways can the medical legal process be improved to satisfy the purpose that has been identified as the system has been utilized? So their focus will be on the medical legal process, the QME process, and that will be their big task to try to figure out how to clean up those 2 programs. Now, this is something that I see that is going to be on the table next year, and they're already talking about it now. The Commission on Health and Safety and Workers' Comp met on Friday, this last Friday, the 13th, I think, and the director of the DIR, Katie Hagan, spent 2.5 hours talking about, she was supposed to talk, let me back up, she was supposed to talk about the Supplemental Injury Benefit Trust Fund, but instead she got off on the CalOSHA and what they're going to be doing. And so but I want to talk about the Supplemental Injury Benefit Trust Fund, and then I could tell you about what she said on the SIBTF. And I think part of it was that they, on the agenda, she was going to talk about potential regulations and legislation. And I think that DIR decided that this is not the time. The commission is not the venue to be talking about legislation when the study is so new, the RAND study is so new. So she talked a lot about Cal OSHA. But what they found with the Supplemental Injury Benefit Trust Fund, the SIBTF, is that the benefits have been, new applications have been rising dramatically. And in 2022, there were approximately 3 times as many applications filed that year. 2488 were filed in 2014. Filed that year in 2022 as compared to 2014, that was approximately 850. So the study that was commissioned by the Department of Industrial Relations was, why do we have this like quadruple increase, in the, under a decade? And so what RAND came back to say was basically that this program is can potentially cost employers $7 billion to fund if these claims keep rising at the rate that they have been between 2014 and 2022. And so there was a question in terms of process. Why do we have this sudden increase? And of course, everybody wants to point fingers as to why these benefits are being possibly overutilized, or maybe there is a bigger workers' comp population or workers filing claims. But that data doesn't seem to match the Workers' Comp Insurance Rating Bureau or the California Workers' Comp Institute's data in terms of numbers of claims being filed. But there is an increase. They were basically saying that the sharp increase in the numbers of the new SIBTF applications filed, impacting the process and adjudication of claims. There are now more than 15,000 pending unresolved SIBTF cases in the system. That's where they get the potential cost of $7 billion. And that, I think, is something that we're going to be looking at for sure. And then so this is just some background information on the SIBTF. I don't want to have to read it to you, but it's pretty mind-boggling that how these benefits are being used. The Supplemental Injury Benefit Trust Fund are for those permanent disability benefits to make sure that the worker is taken care of for the life of their claim. And so those go beyond just the workers' comp permanent disability benefits. These are additional benefits that go to the injured worker. And so they're finding that more than 70% of the recent SIBTF cases that have been resolved as 100% permanent total disability cases, and this is significant as there would be hundreds of thousands of dollars difference between a case resolved at 99% versus 100%. So versus the permanent total disability as opposed to permanently disabled. I think they're the same, but there is a big percentage difference between your 99% disabled or 100% disabled. And so in final, as far as what they're looking at, is the report highlights a significant increase in annual total payments from the SIBTF fund, rising from 13.6 million in 2010 to 232 million in 2022. And that's an estimated 7.9 billion in total potential liabilities based on cases pending as of May of last year. So that is alarming to many, but at the same time, we need to know why these more cases coming into the system, and the potential cost in the billions, the 7 billions to almost 8 billion. I've also heard others say this could go up to 10 billion. So as in May of 2024. So it'll be interesting to see what they are coming up with. But they're looking a couple of the key points that Rand noticed was that the applicants are more often asserting various common health conditions, chronic conditions, and or common conditions of aging as alleged prior permanent partial disabilities to support these SIBT cases. They're also including GERD and hypertension and arthritis and headaches, etc. Back problems are also commonly assertive, and those can be aggravated and could also be permanent. And so finally, the DIR is studying this report closely. They're in favor of maintaining the SIBTF program with the goal of making the program sustainable and fair for the injured workers. So in other words, we're not going to get rid of it, as Rand had suggested. Rand had suggested that other states have gotten rid of their SIBTF and have put more dollars in the permanent disability benefit side. And then also they want to make it sustainable and fair for the injured workers while recognizing the impact to the employer in terms of the cost of the system. And I'm going to talk a little bit about this in terms of the forecast for legislation in 2025. Okay, any questions on the SIBTF?
No questions, Lori.
Okie doke. So then the other key issues affecting labor and management. This is this is what the word is. Coming from discussions amongst labor, amongst the employer community. There have not been negotiations going on. In other words, that grand bargaining table has not been opened yet. For several reasons. I think, as I mentioned earlier, we've had a major changeover in the legislature, and I'll get into that. But it's simmering, the pot is simmering. Permanent disability benefit adjustments for the last few years, pre-COVID, labor has said, it's been 10 years and now 20 years since we've had permanent disability benefits adjusted. And that was all part of the 2013 bargain, and even going back to 2004 when we had the creation of the medical provider networks, giving the employers 100% control of the medical in the work comp claim in exchange for some pretty ample permanent disability benefits for the injured worker. So that was the grand bargain. Well, so now here we go to 2025. And with the recession, with COVID, they've not seen any adjustments in permanent disability. So of course there are studies, going on, where are we in California compared to other states on the permanent disability payout. And so we will definitely be seeing reports on that coming up in January that would either back or give us more information in terms of calculating what that increase is, or are we close to what the other states are paying. But keep in mind, California is the most laborious state, and we are the most high-paying state. In other words, the workers, you can't really compare, workers in California, their salaries, their benefits, et cetera, to Texas or New York or Wisconsin or Illinois. We're, kind of the state that has, more labor and high manufacturing, et cetera. So what are some of the other issues, right? So we know that labor is very interested in looking at the PD benefit levels. We know that the employers are very concerned about the cumulative trauma disorder. And I think that this topic, the CTD claims, may come into play with the SIBTF. How is, are these cumulative trauma claims, are they also being paid out into the SIBTF? Is it are we double dipping? Is there some way that we can adjust the payments out of the SIBTF or adjust payments coming that are given for CTD claims? I see that coming up, and I hear that from a lot of employers that the post-termination or those claims that happen after the employee has left, that they come back with the CTD claims, and those are compensable. So I see some changes or at least discussion, and some negotiating on that. And then the expansion of presumptions. As we saw in the first couple of bills that the governor vetoed, they are definitely looking at expanding presumptions for park rangers, for I'm trying to think, the water sheriffs, the sheriffs that are out there on the lakes. Well, they're out, they're out in the water in the sun and are exposed to cancer, just like lifeguards are. And so if lifeguards have a presumption that their job caused their cancer, their exposure, then perhaps the sheriffs do too, who are out in the water. So it's expansions of presumptions for nurses, for first responders, et cetera. I think at this point, this governor is basically of the opinion that the scales of justice tip in the favor of the injured worker. So if you have a job that requires you being outdoors, you have a pretty good argument that the injury that you suffered, whether it's cancer, and these are usually cancer presumptions, was exposed on the job. You were exposed to on the job. And then the AI in the work comp system, holy cow, that's going to be a huge issue. It's big now, right? It was a big issue. Artificial intelligence, both in the developers, both in those who use it. And let's face it, we all use artificial intelligence. We're all using AI. Senator Wiener had a bill. I didn't include it because AI was kind of out of the scope of the workers' comp system, but it does impact our industries. And basically, Senator Wiener out of San Francisco had SB 1047 that the governor waited till the last minute, the last day to take action on this bill. We all thought he was going to sign it, even though there was a broad coalition of employers saying we're all users of AI, and some are developers of AI. What the discussion had been 2 years ago was to put together a group that could come forth with best practices. How can we not harm the public if we're developing AI, and to make sure that, that the AI is being used correctly, and that it's not being abused or used in an inappropriate way for the consumers. And so, absent the best practices, Senator Wiener introduced his 1047 that basically put penalties for any AI developers or users who put any trauma or, I said trauma, I'm sorry, any harm was the word they used, to the consumers. Well, unless you have the ground rules to know what those, to know what violations you're having, people would be exposed to penalties and not know how they, what they did wrong. So the governor vetoed 1047, and but in the veto message, he said that he will be working with Senator Wiener, the author, in the next legislative year to put together that list of best practices. And so we will be involved in that discussion to make sure that, especially for those for you all in the coffee service industry, how that would impact you, and make sure that your input is put into the discussion. So those are the issues I see. Are we going to see, workers' comp benefit adjustments next year? I'm not a betting person, but I think we will. Oh, that was it. What am I missing? Oh, let me also just mention another thing too, is we have an interesting year next year, going into 2025. We have 34 new legislators that have joined the Assembly and the Senate collectively, 23 in the Assembly and 11 in the Senate, which is a major turnover. And this hasn't happened for like the last 10 years. 2014, we had some pretty good changes with term limits, but this year we had a lot of legislators running either for the U.S. Congress or U.S. Senate. We also had a lot of Assembly members who aren't term limited out until 2030 leave the Assembly to run for an open Senate seat. So we have a lot of switching around. I think there's four legislators who moved from the Assembly to the Senate. So while they're not new faces, they're in a new House. They'll probably be in new committees, although if they were in, for example, Assembly Insurance Committee, if they were dealing with workers' comp in the Assembly Insurance Committee and they moved to the Senate, they're probably going to want to move to the Senate Labor Committee that handles workers' compensation issues. So that's going to be a change. So there's a lot of, new faces to meet, and introducing them as far as the importance of the copy service industry in the workers' compensation, workers' compensation system. That's very important to have those discussions. Also, I think what was like, adding more interest to the whole thing and the work that's going to have to be done in 2025 is that we have a new Assembly Insurance Committee consultant. And we also have a new Senate Labor Committee consultant. And so the one in the Assembly is not going to be named until January 2nd when the legislature, or excuse me, January 6th when the legislature returns. The new one just started 2 weeks ago. She came from Senator Durazo's office. She has a very strong understanding of labor issues, but not necessarily the workers' compensation system in terms of the players. So I met with her last week and kind of gave her the history of the importance of the system and who the players are. And so she's got while she's very smart and very sensitive to labor, she will have a learning curve coming in with, the new bills that we expect to see. And then the mystery is who is going to be the committee consultant in the Assembly that will be handling all of the workers' comp bills. So that will be the interesting thing that happens. I'm just looking to see if there's anything. We have the same speaker, Robert Rivas, and we have the same Senate President Pro Tem, Mike McGuire. We have a very strong rural caucus, legislative women's caucus. We also have not majority, but we're over 50 women, which I thought I'd throw that out there for the women on the web in the webinar. We have over 51 legislators who are women, which is a record. And then, interestingly enough, coming up in the next 2 years, I was just going to mention very briefly the governor's race, where you have 3 women who are running. And I think it's 3 men too, but you have 3 women who are running. So California is going to be interesting, especially since some of the other states have elected women governors. Women are elected in high offices, and California has never had a woman governor. So it's going to be some interesting times in 2025. And you guys know that in 2026, when they do have the governor's race, 2025 is going to be, a lot of positioning, of women in that leadership area. How am I doing on time, Diane?
You're good, Lori. You still have roughly 12 minutes.
12 minutes, okay. Did anybody have any questions or?
No,
everybody's good on that. I'm trying to think of what there's anything else that I should be mentioning in terms of the changeover in legislation and the bills. I think, we covered the bills. I think we're going to look at permanent disability. Oh, and then the one thing I was going to mention too is that the Ashby bill that was the presumption bill for the park rangers. She's introduced that bill again, and this is, I think, the 3rd or 4th try. But this is a district bill for her very clearly. It's for park rangers in Sacramento County. So she's narrowed it down to 1 county, which will, lower the cost rather than having the entire state, all the counties, cities and counties, which is what the cities and counties said, this is going to increase our cost. So she has put it down just to her district, Sacramento County. I just, I think she's going to amend that bill at some point and make it something different, because I just don't see the governor signing a bill that would work for 1 county when you have 57 other counties out there who would probably try to do the same thing. So that's 1 bill. Oh, and as I was going to indicate too, is that Senate Bill 8 is the only bill that's been introduced so far. When the members came back on December 2nd for their swearing in ceremony, that officially marked the first day to introduce bills in the 2025 for the 2025 legislative session. So 1 bill. There are 3 or 4. I'm trying to remember I think there's 3 AI bills dealing with artificial intelligence, and then we can expect to see many more. And I was talking to Diane earlier, and we start out with like a 3-page legislative report of the bills that are of interest to the copy service industry. And by mid-January, that 3-pager will turn into 77 pages, which is what it does on average every year. And so we can expect to see many more bills, many creative bills, that will be provided and sent out to all of us for review. So I think it's going to be a very active year. You have, like I said, 34 new members. They're going to have district bills that they want to do for their districts. They have their issues that they want to see changed. It could be workers' comp, it could be AI, it could be labor laws, it could be insurance reform, it could be anything. So homeless, of course, we'll see homeless, education, wildfire. We'll see all of those bills, but specifically on comp, as I mentioned earlier, I had been, they're in the swing space now because the Capitol is being renovated. And because the members are in the district, they are not here in the Capitol. They may pop in and out of their office maybe once a week or whatever, but for the most part, staff are here. And so going in and meeting new staff, some of the existing staff that now have been assigned to the new members in the Assembly and Senate because they're experienced staff with a new member, just kind of now finding out where everybody is. Today is the day that they're all moving. And so when I was over there yesterday, the hallways were full of boxes and everything else. So we once memorized where the member's office is. Now that's all going to change by 34, but that's fine. They'll get moved in and hopefully be in their offices tomorrow before a lot of them take off for the holiday next week. So I think I covered everything, Diane.
I think you did, Lori, that was great. There was so much information that you provided to everybody. I think people, until they sit down and listen to an expert like you, who doesn't realize how much is going on in the legislature and what's happening. I'm wondering why, do you think it's a budget issue that the workers' compensation only has one potential bill up right now?
I think it's because they're positioning themselves. I think it's, yes, budget, that you have to be very careful. I mean, that's the first thing that you look at when you're going to introduce legislation is, do I want this bill held in the fiscal committee and the appropriations committee? Because if the bill costs the state of California $50,000 or more to implement, it's automatically put on the suspense file and it's held. And you have a very slim chance of getting your bill off of the suspense file, just like the 1205, SB 1205 by Laird. His bill was basically going to cost the state of California $7 million annually to implement. And that was the one that had to do with the workers paying their meals and lodging and accommodating them to be able to go get their treatment during work hours. Anyway, but those bills were expensive. And you have to think, what's it going to cost the state of California? We're the largest employer, not just the private employers or the public employers.
Right.
Yeah, so it could be, definitely budget. They're going to want to be very careful about that. But also this governor is here for 2 years, and he is going to want to make sure that he shores in his labor support. I know that, the system changes are going to happen. I think MPNs are here, right? I mean, we saw a couple of bills by former Assembly member Reyes, who moved over to the Senate. She's now Senator Reyes. She had a bill that she introduced, I want to say 2 years in a row, 2 sessions actually, so it was around for 4 years, that was basically going to create a competing medical provider network program, a public one. And so whereas we have a private MPN system, right, where we have private networks come in and provide medical treatment to injured workers, this was going to be state run. And DWC and DIR said there is no way that they're staffed to be able to do that, to run it. Plus, we're concerned about the number of doctors in the workers' comp system. Well, the numbers of doctors in the group health side, right? We have a shortage of doctors, period. And so by separating the MPN and splitting it up, are you going to have doctors on both, both sides, right? Are you going to have the doctors in the work comp side? Can that doctor then, be in the state-run program or work for the private? What are the rules? And I think, the folks behind this were the doctors and attorneys who are not part of the MPNs. There's a lot of doctors out there that are not part of the MPNs, and it's because it's the legislative mandate that the MPN chooses the doctors that can be in their networks. So it's not like every doctor gets to be in the network. You are contracted with, like used to be, well, Corvell or Coventry or any of the large providers, Sedgwick. They choose the doctors. And
Right.
so I think there's some disgruntled doctors out there who really, they were pushing Reyes to basically, create this other system so that we can have these doctors also be part of the work comp system.
Well, Lord knows we do need more doctors in the system. I think, we should definitely make that a priority. So, Lori, in my conversations with the DIR, George and Ted, Carol, etc., I get the feeling that they're not interested in doing any sweeping changes to the workers' comp system anytime soon. Do you get that same feeling?
That's a really interesting question, a great question. I think that they're going to go along, or they're going to have to go along with whatever the labor management negotiators want to do, right? And that's a very good question, because we used to have the Sean McNally's and the Martin Brady's, who were the employer representatives on the commission. And then you have Mitch Steiger and Megan Subers, Mitch with the California Federation of Teachers, he was formerly with the California Labor Federation, and then Megan with the California Firefighters. Those used to be the negotiators. Well, Martin and Sean have retired, and they have new employer representatives there. So I think that it's going to be who's going to be commanding those discussions, I think, on the employer side, right? We know the labor side and where they're going to be coming from, but I think I think that the time has come with the issues that we've talked about, the PD, the cumulative trauma, and the presumptions. Although presumptions, I'm not that worried about, really, honestly, because the law is pretty clear, and for the last couple of years, the governor has been vetoing these, presumption bills. But I think it's the permanent disability and the CTD and the supplemental job displacement benefit. Those are the three items on the table. And if they can come to an agreement, then George and Ted and Katie Hagan are going to have to come together on that.
Well, we are right at time, and I did promise that I would share a tradition that my family has started as far as gift giving is. And so this came to be because my husband is a better gift giver than I am. He would tell me what I'd want, and then I'd get it almost right. I wouldn't get it exactly right. And I felt really bad about that. So one year I said to my husband, here's our budget. Okay, this is my budget. This is your budgets. They're the same. Let's go out and buy presents. And we did just that. But I bought all my own presents. And then my husband bought his own presents. He wrapped them all up. I wrapped up my gifts. So on Christmas morning, I would unwrap his presents and I would open it up and it'd say, oh, why did you buy this tool? What is it about it you like? And we still have that conversation and everything. You still get the thrill of opening up a present, but I'm delighted that my husband always gets a good gift. So you might try that. At first, it wasn't something that felt necessarily like great. My husband thought, no, I'm not too sure I like this, but I think we're probably on year 5 or 6, and it's been a lot of fun to do. You always get what you want. So just an idea to share with everybody. All right, just as a reminder, on Monday, we have the last 2 programs for the 12 CEUs of Christmas. We got one on medical stress and good faith personnel actions and how to defend them. And then lastly, myself and Jim Rossi, we're going to be speaking on unlocking successful apportionment. I hope that you guys will join us for those last two webinars. Until next week, thank you so much for joining us, and we will talk to you later. Bye-bye now. Thanks, Lori. You did a great job.
Thank you, you guys. Thank you. Happy holidays.